Welcome to Mastering Legal English, Episode 2, where we focus on making legal English content for lawyers. My name is Charlie Shan, and I'm a Canadian lawyer with a UK law degree who has become a legal English coach for Spanish corporate lawyers. And I'm joined by...
I'm Steve Kahaner, a U.S. lawyer who practiced internationally for several years, mainly relating to Latin America and Spain, and who now owns and runs a language services company focused on the translation of sophisticated legal documentation.
Great. And you may ask why we are doing this. For me, learning French and Spanish changed my life. It helped me get jobs in Canada and Spain that I wouldn't been able to get otherwise. So I really see the power in opening the world market through English for Spanish lawyers. It's not something that most people in Canada or the US really know about because so many of us take speaking English for granted. I've been coaching Spanish lawyers to speak and work confidently in English for almost 4 years now. And this is a great way to talk about ideas that have worked for my clients in the past and methods I'm using right now, too. Steve, can you talk about your motivations?
Well, we've been helping our clients with their English language materials for decades, and I thought it'd be a good idea to participate in a podcast where we discuss what I refer to as comparative legal linguistics and the issues that non-native speakers of English typically have when trying to express themselves in the English language, especially in the legal context, of course, but also in my prior life practicing international corporate, commercial, and securities law. I saw how important it was for any lawyers practicing internationally to have a strong command of the English language, and especially English language legal terms and concepts. And this is because, like it or not, English is basically the lingua franca of international law and business, no matter what jurisdiction you're licensed to practice in.
Great. So today we're going to start with an Ask Us section with our opinions and advice for English and translation. Law practice and English tips, which is often things like terminology, false friends, communication tips for emails, letter writing, speaking in general, and stories from the court. And then we'll finish with a quick word from our sponsors. So, Steve, do you have any questions for me today?
Sure. Let's start with this. Without disclosing any confidential information, tell us about some of the biggest pronunciation issues that your clients have particular problems with.
Well, Steve, can you pretend you're a native Spanish speaker and, I've provided some important terminology. Could you give me an example of how that might be said, and we'll go over some important terms?
I'll do my best. We'll see if I can pull this off. I hope the audience doesn't hold it against me.
So litigation related, we have one that starts with a P.
So I've heard this pronounced as precedent.
Very good. Very close. So precedent, honestly, this is a big one with that R. The R from English and Spanish is so different. It's taken me 4 years to try and figure out the Spanish R. And I think the way you said it is quite authentic, and we would say precedent.
Precedent. Okay. And no sound with the C. So precedent with the S sound.
Very good.
Okay. I see you have another word for me. Breach of contract.
Yeah, well said. So breach, the way that it's spelled is not the way that it's pronounced. So breach of contract. Now, a lot of corporate lawyers, the problems come when a contract is breached. Now, the tendency is that to think that the EA might actually make an EA sound. And there's so many EA sounds in English that are different. And so this one is pronounced more like an EE, breach. And we've spoken earlier, it's not like the EA of pair or bear or beach. No, it is of beach. So breach of contract. That's a good way to think of it. Great. Moving along.
Okay, I see you've given me another word. Let's see how I've heard this pronounced. Affidavit. We had to give an affidavit.
Pretty close. And so I would say affidavit. And this came up all the time when I was working in courts. Everyone needed an affidavit to swear something was true, etc. And so I think it helps to think of David, like the name, affidavit, because it is misleading the way that it's written.
Although in Spanish we would say David, but we're not going to go there. Uh, okay, next word. Very easy. This is very easy. Infringement. There was an infringement of our intellectual property rights.
That's right. That G sound, infringement.
Ah,
And it's going to come up later.
infringement.
Infringement. This one I haven't had in private practice. I haven't had to correct as much as the next one, but that J sound is challenging. Infringement. Thank you.
Oh, this is hard. Okay, we received a sub a sub a subpoena. We received a subpoena from the court.
Yeah,
We
that is really well said from that accent. When we say subpoena, so we totally
subpoena.
forget the O. Otherwise, yeah, it would be subpoena, subpoena, and almost completely ignoring the spelling. The next one, though, I think could be an easier one in general.
Uh, so estoppel, estoppel. This
Yeah,
is a case of estoppel.
and it's not too far off estoppel. It's actually,
Estoppel.
yeah, estoppel. And this is where having a lot of exposure to the language, you can guess a lot of these sayings or the way that they're said. And now, if we
Bueno,
move to
pues no, no
corporate,
más de palabras de litigio. Yo soy un abogado cooperativo y no quiero saber más. Go
perfect.
on.
Now it's time for the hardest one of corporate, the hardest corporate terminology. Go for it.
This is very easy. We need to engage in diligence. Due diligence is very
Great.
important.
Sometimes this is said, and I had not understood it. And so, even though it's spelled DUE, due diligence, it's like
Ah,
DO, due diligence. And that CE's got the S sound once again. And another one that's often corrected is the next one.
we have a very large project that we are going to begin next month.
Uh,
Project.
exactly. So there's a J, and that J sound in English is not the same as in Spanish. And so this comes up a lot when it comes to corporate lawyers, and they've got projects, and they'll often say projects. And it's fine. Steve and I speak Spanish, and so we'll get it. But people who don't have a big exposure to Spanish, they may have no idea what you're saying. And another similar one is the next word.
Ah, he is a very young attorney. He's very young. He's very down attorney, young down attorney.
Yeah,
Young.
exactly. So young, that with that Y
Young.
sound, young. I once had to correct an attorney because it sounded like down, like you were saying, and then sometimes, often, yeah, jung, like almost like they're talking about the philosopher. Now, the next, why don't you give it a shot? It starts with a C, and then I'll talk a bit about
Okay.
the.
In this one, the project, no project, the project commenced in May.
Right now. So
Commenced.
this
Commenced. No.
almost commenced. When words end with ed, you have to be really careful because they can either sound like st or id. So, for example, commenced, it's almost like an st sound, even though that's not how it's written. And then otherwise, it sound like an id sound. So the project started would be an id sound. And so those are traps that you just need to know with enough exposure. Would you like to move on to the last one? Would you say this is hard or?
It happens to come up a lot. That you could say, I often hear that was a very easy negotiation. It was very easy, and maybe you want to explain. what's
Yeah,
off
there.
there.
Yeah, now there's an S. It would read that way if you're just reading it, but we put a Z sound in it, so easy. And if you want to sound very fluent, it's very smart to pronounce it as if it was a Z, like easy. And I want to thank you for taking on that role
Ah,
of the
I'm
English.
thinking if we have any audience members or other friends that may want to come on our podcast one day and be subject to correction as they make a presentation, that would take some fortitude, I think, to subject oneself to that. But it might be fun. It might be an interesting exercise where I'm not trying to pretend to be a native speaking Spaniard, but we have somebody actually come on a future
Yeah,
episode.
absolutely. Now, I believe you have one more question for me.
Not that I see here. I thought we were coming. Oh, that's right. That's right. So what other problems do you come across? Like what do you see?
Great. So recently I was talking to a lawyer, and he said he was concerned that if at the end of a negotiation you kind of burn out, it's been a long day, it's been a lot of work, a lot of questions have been asked, and you don't speak English 7 hours under high stress a lot. And he was concerned that, let's say his English fails at the end of a negotiation, he can be taken advantage of. And I tend to agree with that because after a while, if you're exhausted and you're against a native speaker and they're still hammering you because this is their strength, if you aren't prepared with certain expressions or certain phrases for certain situations to either delay or take a break or just deny or disagree, then that is a real danger that at the end of a negotiation you could be taken advantage of. And you also have a note about this, something that helps
Well,
you.
I don't know how useful it is, but I've often been in situations where I'm trying to speak Spanish in a formal setting, and it goes on for a very long time, um, and it reminded me of, with a drink or two, I tend to become more fluent. The words flow more easily. I can't necessarily recommend that you go get yourself a stiff drink in the middle of an intensive negotiation. Uh, but simply that's helped me in the past, to you know find a way to relax, whether it's alcohol, probably not the best idea in a formal situation, or take a deep breath, and try and really relax oneself, and the words will flow more easily. That's been my experience.
Okay, great. Yeah, and there was one more thing that lawyer mentioned to me, and he was saying that after a negotiation or after a deal is done, if his small talk fails him, then he's kind of outgrouped. He's kind of looked at as he's not, one of them. So he was in a situation where he was with a native English speaking lawyers in London. They went out for drinks after work, and he just couldn't keep up with the small talk, the speed, the slang, the accent. And I remember he was saying, at the time I didn't understand why they kept calling me mate. And, I was hung up on that. And obviously it turns out that it's like, it's a term of endearment. There's nothing really to think about. And then he kind of felt that, well, this is, if I can't keep up with the small talk after, well, that could really lose me a lot of opportunities. I'm not considered one of the lawyers then. And small talk is, a lot of people dislike it, but it serves a really big role, especially when it comes to you with clients. Yeah, there was so much waiting around court for me where, me being very good with calming them through small talk because they want to, before you go into court, they're nervous. After, they need to debrief. And so he was right. Small talk is something I hadn't thought about teaching, but really there's like a fluency when it comes to English. And then there's also the ability of the language. And Steve, I was wondering what your take is on small talk.
I mean, I think it's a very important skill to have. I unfortunately don't have it. I'm not very good at small talk, and I think that's hurt me in my career and doing business. It is a very important skill to have. I've tried to develop it a bit, but I'm a little more to the point kind of guy, and small talk has always been difficult for me. So uh, I would say the more you can develop that skill, the better off you will be. There's no doubt about it.
Absolutely, and it's come up with me with a number of clients when either it's them having to entertain the clients or just keep them company when it comes to long litigation, etc., or they come to visit Madrid. It's something that it, it's easily neglected because there's negotiations and legal English and the actual legal problems, but a lot of people are unprepared and upset when it comes to leaving that to the last minute. And that concludes Ask Charlie for today. And we're going to switch over to Ask Steve. So, my question for you is, what are some common mistakes that you see when clients are translating terms and phrases into English?
Well, we talked a bit about this already. I think we covered a lot of these topics, um, and I'm not sure how much more we want to get into that at this point. I mean, we talked about operación, um, and how that can be literally translated as operation, and in some cases that would not be incorrect. But more often, that term is really better translated as transaction, the transaction that's being discussed, which would be the more appropriate term. But the term transaction is really not appropriate in other cases when you have to refer to the transaction in question itself in order for the phrase to make sense. So it could be a loan, a merger, a public offering, whatever the deal in question is, you want to refer to that rather than say operation or transaction in English. It just doesn't make a lot of sense. Another issue, I've been noticing this for a long time, and nobody else seems to talk about it, is the use of the Spanish word "o" when you're providing a list of subjects. So there may be a sentence like, I just came across this. Nuestro bufete presta servicios en varias áreas de práctica, como tales como derecho mercantil, derecho laboral, o derecho fiscal. In English, saying that our firm provides services in various practice areas such as commercial law, labor law, or tax law makes no sense in English. It's not one or the other, it's and. In Spanish, and I still need to do a little more research as to why the conceptually why they use the word o rather than e, which means and. I'm still not sure of. What I do know is that in English, you would not say commercial law, labor law, or tax law. You would say and tax law. Uh, there's no question here. And finally, there's the issue of shall versus will. So this is an issue on which there's a lot of debate, even among native English speakers. There's a lot of debate back and forth as to whether it's more appropriate to use will or shall. Let's say in contract drafting. Um, but if you're explaining a piece of legislation or a contract to an English speaking lawyer or client, you're going to have to choose how to translate into English something like el objeto, el local objeto de este contrato se destinará única y exclusivamente a oficinas. Typical lease agreement language. So, should this be translated as the premises covered by this contract will be used only and exclusively for offices? I don't know what you think, Charlie, but at the risk of sounding pedantic, I would say no. I would say we mostly prefer to use shall because shall has exactly one formal interpretation. It's a command establishing a duty or an obligation on someone to do something. On the other hand, will is more amorphous and doesn't necessarily convey a mandatory aspect. Simple as that.
Yeah, I could see
Speaking of
someone.
formal, yeah, and speaking of formal, I think we're going to switch to some illustrative stories from court. Is that right, Charlie?
Yeah, I have a story about this was recently by a lawyer, how being a native speaker doesn't necessarily make you a great communicator. And I keep thinking about that. So I think
So,
did I
you told me you had a story about somebody, a client who said, "Whoop de doo."
right? I was in court representing a little old woman, and we were suing one of Canada's biggest corporations. And
Well,
so
that sounds promising, right?
yeah, the judge actually just sent out the company representative and his lawyer, like out of the room, and asked us if we were out of our minds, and which basically put us on the spot. And we actually did a really good job showing how we could win.
That sounds good.
Yeah, so far so. But then the judge brought up they had brought expert evidence, and when he brought that up, my client just yelled, "Well, whoop de doo!" And it just made me and the judge jump because she like screamed it. Yeah, you know.
How do you? Well, first, how do you explain what "whoop de doo" means to a native Spanish speaker? And secondly, how do you recover from that?
It's a hard thing to explain because it really doesn't mean anything. Would you say
I,
it means
I think,
anything?
well, the way she said it, well, "whoop de doo" means, well, so what? So what? Basically.
Right. And so the words don't really mean anything, but the expression really means, yeah, who cares? So what? It doesn't bother me. And so, but yeah, to your other question, how do you recover from that? And it's quickly. This is a highlight of my legal career. Before the judge could respond, I quickly said, what my client is trying to say is that we don't consider that evidence convincing because the investigation was not done thoroughly.
Which is exactly right. That's what she meant by "whoop de doo."
And so I really thought that that's a good example of how a native speaker just pretty much ruined her lawsuit with a 100-year-old piece of trash talk. But in a way, it worked because it helped the judge who was not questioning the expert evidence. He basically just saw expert evidence, took it at face value, and then was shocked out of his chair by, well, whoop de doo. Was able to forgive her outburst after I explained it. You know, I kind of translated that into legal speech of, you know, the reason we don't understand that, Your Honor, is we don't consider this evidence to be substantive, you know, and that I mean, you could say, well, whoop de doo is, you know, yeah,
Shorthand. It's shorthand.
great, and
So
it.
non-legalese for the same thing. Yes, very smooth, very well done.
Thank you. Yeah, and it's part of the reason we are hired. And so, if we're working in English and Spanish, this is part of our job. And I actually have another story about this. You know, how being a native speaker doesn't necessarily make you a great communicator.
Uh, well, we've talked about that for small talk, but are you talking about something else?
Yeah, I was talking to a lawyer who was thinking about coming on the show. He was asking, well, what would I talk about? And I know some of his work. You know, he's like, well, what would be of value, you know, for like a legal English for Spanish lawyers podcast?
He's a native English speaker.
Right. He is. And he was in basically, and he was in court in English. It's a divorce trial. The judge had enough. You needed to take a break. And when he was leaving for the break, he told the parties, you know, while I'm gone, you know, doing this paperwork, see if you can negotiate while I'm away.
That sounds normal.
Right. You know, use your time constructively. And so the judge leaves, and this lawyer turns to the divorcing husband and said, you heard the judge. What are you going to do about it?
Interesting choice of words. Yes,
And so,
in a very tense situation.
right. So
What happened?
the husband jumped up in anger and he chased the lawyer around the courtroom while the
Nice.
wife and opposing counsel just sat in shock. So the lawyer was being chased in circles around the courtroom. In the end, he was dodging behind the judge's desk, the angry husband, who then realized, well, I'm not going to catch him. So he picked up a jug of water, a big like vase or jug of water, and threw it at his head. The lawyer ducked. It hit the door behind him, and it made like a gong sound. I guess it was metal on metal, and it reverberated. It like the whole courthouse heard it. The security came in and restrained the husband, and
That's something. Wow.
yeah, it was such a big deal. It made the local paper. They had a cartoonist draw a political cartoon of a lawyer ducking a flying jug of water.
So I'm imagining the scene now, but maybe we should take a closer look at the language he used and what he said.
Yeah, absolutely. And I looked. Part of this is going to be under the heading of "Ask Steve" instead of the law practice. I just fixed that now. So what we can learn from this, the reason I thought about it is he's a native speaker. He's a very experienced senior family lawyer. But I would not say that this is a highlight of excellent communication. And so I was thinking about our advice from last week as well. I would not recommend speaking so aggressively when you're one in court, two for a divorce, three, it's been a long time. Last week, we recommended being as polite as possible in adversarial situations, which probably would have avoided this.
So what language might you have used that would be different in that case?
I was thinking about this, and I really think it depends on the case, and it depends where you are in the case, where you are in the negotiations as well. And if that lawyer does come on the show, we can ask if he remembers more of the details. Maybe he could have opened with obviously something else. But divorce cases can be really specific. I know from speaking to him, different cases could be over who owns the canoe, who owns the dog, who fixes the pool liner. And so I told him that is an excellent story for us because it really shows that a small change in tone or word choice can really give you drastically different outcomes. And as lawyers, we work in stressful situations, we use words. And if we misuse words, I mean, normally when it comes to language differences, you could be misunderstood or not understood. But things like this can happen as well. And it also made me think when it comes to the cultural differences, Steve. My question for you here would be: what advice would you give a Spanish lawyer, particularly when advising an American client?
Uh, I mean, I think we touched on this a little bit already, but Spanish lawyers, um, traditionally, I think things are changing, and I think as I said, the systems are converging, and people are getting more and more used to what foreign parties expect. But Spanish lawyers used to keep their answers strictly to the question raised. So if they're presented with a question from foreign counsel, um, they'll answer that question and that's it. And they won't necessarily anticipate related issues. And this has been frustrating for American lawyers who have their business mindset um, and kind of expect an anticipation of problems that may not be directly related um, to the pointed question in front of them, and and so anyways, it's an area that a Spanish lawyer should be aware of, that the American client will often expect them to say, hey, this is the answer to the question, but with a slight change, you should be aware that this would be a different answer. The answer will change, and this will avoid the American lawyer from having to ask a question from 15 different perspectives to make sure that they've covered tangential issues that might have an impact on their client. So the more philosophical, erudite, professorial approach of just answering that specific question is not going to fly very well with many American clients. They really do expect the lawyers to be more proactive, and help them anticipate the issues that are going to come up or that may come up.
Right. And then when it comes to expectations, so if there's a concern about the scope, if there's a concern about how expensive it might be, would you recommend a Spanish lawyer ask, would you like solely a legal perspective? Uh, or would you like to add a business perspective if they're concerned, about
Um,
either billable hours or something like that?
I'm not sure if it's necessary. I mean, it'll never hurt to say, "Hey, do you just want a specific answer here, or should we expand upon it?" It depends on the billing arrangement and whether additional time may be authorized. If you have to draft a few more pages, then it's probably a good idea to make sure the expectations between the client and the lawyer match as to what's expected from the parties.
Great. And then when it comes to cultural differences, English is generally shorter. Would that mean that English contracts would generally be shorter than Spanish contracts?
Well, yeah, no, it's the reverse actually. Even though yes, if you're translating from Spanish into English, we usually calculate about 15% fewer words in English than in Spanish. But in terms of length of contracts, the reverse is true and to a much greater magnitude. A typical 5-page contract in Spanish, which are short because traditionally the lawyers have felt that the civil code and maybe the commercial code will fill in the gaps where the parties haven't specifically dealt with an issue. And since the parties all know what's stated in the civil code and the commercial code, that's fine. That works. Under the common law system, as opposed to the civil law system in effect in Spain, but the common law system in the UK and the United States, most of Canada, um, the parties' freedom to contract and their ability to tailor the contract to cover all of the contingencies has traditionally been the approach used. So, an American lawyer will try and cover most of the contingencies that might arise in the business relationship between the parties. That means you have to specifically enumerate and discuss all of those contingencies, and that leads to a much longer contract. So, what is 5 pages in Spanish could be 20 pages in English easily. And that is typically horrified the Spanish lawyers on the one hand and the American lawyers on the other hand when they see a 5-page contract, excuse me, for a $1 million deal. And that's just you know differing expectations. But again, I think I see more and more contracts that are quite extensive that are very American style. I think the Spanish legal system has accommodated this different approach, and it's not unusual to find American or British style contracts drafted solely within the Spanish jurisdiction.
Okay, wonderful. Thank you. It's a funny difference where, from a pure language perspective, Spanish is longer. And then from a legal perspective, the code covers so much that it is drastically shorter. And then perhaps there's the legal, litigious American reputation that has people add an extra 10 pages to some of some of those contracts.
I'd
Um,
love for the audience to let us know if you disagree or you have any questions. Would really love to hear. You know, even before we were talking about pronunciation, if there are particular words or phrases that you have difficulty with, I think it'd be a great idea for people to pipe up, as we say, and throw that out there. We won't name or shame people. Maybe just use first names, but I think it'd be great to open that up if anybody has any comments.
Yeah, if you have any comments, let us know, and we'll put it on for the next live stream. And but I think that's it for today. Would you agree, or is there anything else you'd like to mention?
I think we've covered what we wanted to cover for today.
Excellent. And then that means it's time for us to thank our generous sponsors. This week, we're sponsored again by Charlie Shan Coaching. I do coaching work for lawyers who want to sound powerful and effective in English. And Steve?
Well, at Juriscribe, we provide timely, accurate legal translations for our clients' most important corporate and legal documentation. Our translations are provided by lawyers for lawyers. Contact Steve and find out more.
Great. Thank you very much, Steve, and everyone watching, and we'll see you next time.